Well, good afternoon, everyone, and welcome to the McGuire-Woods Labor and Employment and OFCCP Federal Contractors webinar series. Today, our topic is the 2019 National Industry Liaison Group Conference Recap, OFCCP, EEOC, and the federal fiscal year ahead. My name is Brian Barger, and thanks to everybody for tuning in. Before we get underway, let me just mention a few housekeeping items. First, on your webinar screen, you should see several widgets toward the bottom. Let me call your attention to a couple in particular. First, the green marketing materials widget includes a copy of the presentation itself. A link to those materials will also be sent to you separately by email. Second, you will also see a purple Q&A feature. Please use this to submit any questions that you have throughout the webinar. We'll be leaving all questions to the end of the program, and we'll do our best to get to what we can. However, for any questions that we do not have time to cover, we'll follow up with you separately and individually after the program is over. So feel free to have at it. Please also note that this presentation is being recorded. We'll circulate a link to the recording together with the webinar deck and an evaluation form after the presentation has ended. We'd greatly appreciate it if you could complete the evaluation, as it helps us improve our offerings and think about interests for future topics. So that's it for housekeeping. Now on to the ILG recap. To begin with, for those of you on the webinar who are not familiar with our firm, I thought I would just mention that we are McGuire-Woods. We are an AmLaw 100 firm with roots dating back to before the Civil War. We have 1,000-plus attorneys and 26 offices across the United States, including internationally. And the bottom line on that is, if you didn't know, once you cross 1,000, I think the legal term for that is a gaggle of lawyers. We have a gaggle of lawyers in just about all practices and industry areas you could think of, including my practice area, which is labor and employment. As I mentioned earlier, I am Brian Barger. I'm a partner with McGuire-Woods in the Charlotte office. I've been practicing labor and employment law for over 29 years, going on almost 30. My practice focuses on federal contractor defense and compliance and corporate employment counseling and risk management. I went to UVA, both undergrad and for law. Grew up in Virginia, moved down to North Carolina afterwards. Love living in North Carolina. I particularly love North Carolina barbecue. It's the best thing about being in North Carolina, although I have to say I can't stand Duke basketball, and it is the worst thing about being in North Carolina. So sorry to all the Dukies on the call, but go Hoos. So that brings us to the National Industry Liaison Group Conference itself. As part of my federal contractor practice, I just returned from that conference in Milwaukee, which was held at the 1st of August. I presented again this year at the conference along with a couple of regional directors from OFCCP, which was a lot of fun. I also attended a number of different presentations and meetings with OFCCP, EEOC, and other regulators, and you can pick up a lot from going to those conferences. I highly recommend them. For those who aren't familiar with the National Industry Liaison Group, it is a government and industry partnership between private industry, the EEOC, the Department of Labor, OFCCP, and other regulatory agencies to provide input on regulations and enforcement priorities that impact employers. In theory, it's sort of government and industry working hand in hand in partnership for a better tomorrow. Picture industry individuals and lawyers and government officials, walking hand in hand on coals singing Kumbaya. It can be a great thing. In practice, I have to say, after a week of hanging around regulators, you're glad that they had the conference in Milwaukee, in a city that's known for beer. So with that, I'll jump into exactly what happened at the conference and some things you might want to pay attention to. Overall, I would say the biggest takeaway for this year is that even though we are now 3 years into the new Trump administration, and there is no doubt that there is a change in tone, which is positive, and definitely a change in transparency, which is also very welcome. Having said that, overall, many of the things that we're going to be talking about today, and many of the things that you're probably experiencing as contractors and otherwise, it's surprising, frankly, for a Republican administration. There are definitely some improvements, but the speed of those improvements are fairly slow, and the scope of them for things that have real meaning for most employers that we represent are fairly limited. And in fact, some of the things you're going to hear about today, you may scratch your head a little bit and ask yourself, is this really a Republican administration proposal? In fact, if you'd heard some of these proposals a few years back, they would not surprise you. So that's the big takeaway, is that there's change, but it's glacier, and some changes, frankly, aren't all that welcoming. Speaking of non-welcoming changes, that jumps us into the first topic, which I think is on the top of most everyone's sort of minds today, and that's EEO1 Component 2 reporting. And so what I thought we'd do as we kick things off is go over a few refresher points for those who aren't as familiar with that reporting obligation, and then talk a little bit about what we heard at ILG and what we're recommending to clients. As a refresher, EEO1 reporting historically has had just one component. It's the current EEO1 form that most employers are familiar with. It required individuals to report race and gender data throughout your organization, both in a component form and for individual establishment locations, in addition to your headquarters, and is broken down by race and gender data into each of 10 artificial job categories such as professional, or technicians, or sales workers, et cetera. That has been the law for a number of years, and employees and employers are fairly familiar with that process, and for completing that form, it's nothing nothing unique. What is new is the new Component 2 requirements that impose obligations on certain employers to preserve and to report out on aggregate compensation and hours worked data for all of those same employees that you normally would do on the EEO1 Component 1 form. But in addition to race and gender data broken down into 10 categories, you're now required to also break down that data into 12 individual pay bands within each of those particular 10 job categories. Very burdensome. So who's required to do this? Well, under Component 1, if you'll remember, Component 1 primarily covers private employers with 100 or more employees, and federal contractors and first-tier subcontractors with 50 or more employees. Component 2 is slightly different. Component 2 only covers private employers or federal contractors and subcontractors with 100 and more employees during the 2017 or the 2018 snapshot reporting period. So it's different than that 50 cutoff for federal contractors. The cutoff is 100. Excluded from that, I will note, are entities like state and local governments are not required to file Component 2s, public, primary, and secondary schools, institutions of higher education, and there are a handful of other limited exceptions. But the way the coverage works, in order to hit the threshold 100 number, you take a look at the snapshot reporting period that you yourself as an employer select, which we'll get to shortly. And if you're reached that 100 threshold during that given snapshot period, you're required to provide Component 2 data for 2017 or 2018. So depending on the number of counts that you have, you may be obligated to file for one, or for both, or for none of those 2 calendar years. So what are the core requirements? Well, as you may have read, it's a couple of things. First of all, you have to think about who you're going to report, and who you report depends on an employee snapshot period that you yourself select between October 1 and December 31 of the given calendar year. So that's between October 1 and December 31 of 2017, or between October 1 and December 31 of 2018, both years. You yourself select the snapshot period, and the snapshot period can be different than the snapshot period that you selected for both of those years for purposes of EEO1 Component 1 reporting. You certainly can use the same date if that's easier to pull, but if for strategic or other reasons you choose to do a different date, that is allowed as long as it's within the October 1 to December 31 period. What else are you required to report? Well, in addition to who counts, what do you do once you figure out who? Well, for those individuals that are now on that list that you figure out within the snapshot pay period that you pick during that period, you're now also required to pull and report out aggregated W-2 Box 1 comp data for those individuals, which is more than just base pay. And you're required to put that into 12 individual designated pay bands that are determined separately by EEOC. In addition to the comp data, you're also required to report related hours worked data. And there are two ways to do that. For non-exempt employees, you are stuck reporting actual Fair Labor Standards Act hours worked, which includes overtime, but excludes things like paid leave, vacation, FMLA, et cetera, when people are not truly, quote, working within the FMLA definition. That's for non-exempt employees. For salaried exempt employees, people who are exempt from the overtime requirements of the FLSA, you have two choices. You can report either A, actual FLSA hours worked. Of course, for most exempt employees, you don't track hours worked. That's part of being exempt. And so unless you're a lawyer like myself or an architect or someone else who actually does track hours, most of the time you do not have a good reflection of what an exempt employee actually works. And if that's the case, the EEOC indicates that you have a choice. You can alternatively report, quote, proxy hours. And they tell you what the proxy hours are. The EEOC in their instruction book indicates that the proxy hours for full-time employees are 40 hours a week, and the proxy hours are for part-time employees are 20 hours a week, and you multiply that by the number of weeks that individuals were employed during the calendar year in question. That's the core requirements. So where did all this come from? Well, I know it's sort of like a bad nightmare, or at least a recurring nightmare, but this originally came out of 2016 EEOC regulations proffered by the Obama administration before they actually took effect and individuals had to begin filing. There was an August 2017 OMB stay, the Office of Management and Budget stay, pending review that came out under the Trump administration. That was immediately followed by litigation by various interest groups who were not happy with that stay and wanted the Trump administration to proceed with the collection of the data. That lawsuit has rocked along, and in April of 2019, the D.C. Circuit Court ordered that stay be, in fact, lifted and ordered the EEOC to begin requiring that the reports proceed. As part of that order, the court gave the EEOC a choice about how to move forward with the reporting data, which the EEOC then elected to do. And in May 2019, the EEOC chose that employers have to move forward with reporting data for both 2017 and 2018 by September 30th of this year, 2019. That portal, quote unquote, the EEOC survey portal opened up in mid-July for Component 2 reporting, and the EEOC published a number of instruction guides and FAQs and samples and other information about that. It's also important to keep in mind, frankly, that there is an appeal ongoing in the background of all this. Just as in any litigation, you can appeal that decision. OMB and EEOC did appeal the district court's decision back in May, and that appeal remains pending with the court at this time. So you may ask yourself, given the appeal, what does that really mean? Is this really going to happen? And that was the number one topic of interest, as you can imagine, at the National Industry Liaison Group conference. That remains, frankly, the number one topic of interest to this day. But I will tell you, at least from the perspective of the commission itself, and frankly most individuals, I think it is going forward, and I don't think there's much doubt about that. Whether things happen after the September 30 deadline is a more interesting question. But EEOC Commissioner Victoria Lipnick was at the National ILG conference. She's been good about coming in the past and came again this year. She is not a fan of this pay data reporting for a variety of different reasons. But she said very clearly, quote, they, quote, the reports are going forward. Nothing is going to stop them between now and September 30th. And there are a number of reasons for that, but part of it, keep in mind, is that the EEOC is under a court order to do so. They already went back to the original district court early on when the order was out and basically pled their case that regardless of the merits of the court's order, the EEOC simply wasn't ready. They didn't have the portal ready, they didn't have instructions ready, they didn't have training. Employers have not been collecting and compiling this data in order to prepare for September 30th filing. That was going to be burdensome on the EEOC, burdensome on industry, not enough time, not enough preparation, etc. And the court would have, frankly, none of it and insisted that things go forward on September 30 as is. The other reason that there's really probably nothing that's going to happen in the ta-da nick of time before the September 30th deadline has to do with the briefing and filing schedules, frankly, on the appeal. The appeal, like I said earlier, was filed back in May, but there was no emergency stay request to the appellate report that we've seen. The EEOC didn't file its appellant's brief until just recently on August the 19th. The response by the plaintiffs in this matter are not due until September 18th, and the reply brief from the EEOC, should it wish to do so, is not due thereafter until October the 9th, which is after the filing deadline. So is there going to be some sort of ta-da in the nick of time reprieve that gets us all out of this, sort of like what happened with the DOL overtime salary threshold rules several years ago under the last administration? It's possible, I suppose, in theory, but everything's possible. Do I think it's likely? No, I don't think it's likely. And I think most commentators also think it's unlikely. The more interesting question is, will there be some sort of post-September 30 deadline extension or reprieve of some type? As for the deadline extension, it's probably likely. We'll have to see. Certainly, the EEOC already asked the court to extend the deadline early on when they issued the original order, and the court said no. Of course, we'll have to see what happens. You know, the EEOC has not tested these systems very rigorously, and to the extent that thousands and thousands of employers start uploading millions of gigabytes of data into the system at the end of August, at the end of September, and the system, in theory, crashes, it could require an extension of some type. And I can see the EEOC definitely going back to the district court and maybe asking for some additional time, or at least keeping the portal open, as they normally do for EEO1 Component 1, for a certain period of time after the deadline. So do I think a little wiggle room after September 30th is possible? Yes. Do I think the appeal itself will be victorious and that we'll get out of this on appeal after September 30th? Don't know about that. The hard part about all this is the appellate court could just simply punt and argue that the appeal is moot because employers have moved forward with file. And regardless of the merits of the EEO1 reporting data itself, it's happened, such that there is no reason for some type of emergency stay on the appeal. So we'll just have to see what happens. But regardless, my best guess is September 30th is a hard and fast date, and EEOC expects compliance and will be looking for you to file if you're a covered employer. So what does that mean from a strategic standpoint for you as employers? Well, you know, you have a couple choices, I suppose. Choice number one is to just go ahead and file to the extent you're required to do so. Obviously, the pro in that is it's fully compliant. If you're a federal contractor, you have other obligations in audits, et cetera, where it can be a technical violation for not filing. Frankly, it's good for internal optics to be able to say that you're compliant and are certainly trying in good faith to comply as best you can with the reporting obligations of the law. The downside, frankly, is the data is, as the French say, garbage. It is not good. And I can spend hours telling you why the data is ridiculously bad. But part of it, beyond the fact that you're not comparing similarly situated employees and similarly situated groups, is that the wage data itself is inherently flawed. If you're pulling W-2 Box 1 data, think of all the things that go into that. You know, shift differential pay, overtime pay, performance-related bonuses, other things that are outside somewhat the scope of the employer and much more in the scope and obligation of the employee with respect to control. So comparing those data for individual employees is really comparing apples to oranges. Likewise, W-2 Box 1 data excludes excludes a number of bits of information. For example, it excludes elective deferrals that employees themselves raise their hand and choose voluntarily to defer. So, for example, I can have two employees, both earn $75,000 a year, both being paid in the exact same methodology for the exact same job. So one does a 401k deferral of $5,000, one does a 401k deferral of $0. One has a Box 1 W-2 income data of $75,000, the other shows $70,000. But in fact, they earn the exact same amount of money in the exact same position. That's just one example, and there are thousands of examples like that. But overall, the data is going to be bad. And as a result, to the extent anybody at the EEOC or elsewhere uses that data for statistical analysis, it will generate false positives. There's just no doubt about it. The other downside to filing is, frankly, once you file it, it's done. It's out there, and it's a public record. Now, whether or not it's subject to FOIA is debatable. The EEOC is taking the position, I think most employers will be taking the position, that it's not subject to FOIA disclosure under exceptions 3 and 4, but there are other exceptions to that. And there is the possibility that individuals can get into FOIA actions to force disclosure, and I think that makes a lot of employers nervous. Frankly, there is also the more likely risk that you may have to disclose it in the course of litigation, so that if you get sued for a discrimination claim or, God forbid, a comp discrimination sort of systemic claim, plaintiffs' lawyers can ask to see your EEO1 Comp 2 data. And they might also be able to ask and try and identify in discovery the underlying data pieces that go behind that. So that's risky. So filing away is certainly compliant, but it has its own risks. Option number 2 is you can choose not to file. Now, the pro of that is there's limited penalties for that. There is no financial fine or penalty for not filing a Component 2 or, frankly, a Component 1 report. You do have financial fines and potential risk for filing a, quote, willfully false report. But for not filing, there is no monetary penalty. Now, for federal contractors, again, that's a technical violation that can create other issues. For non-federal contractors, that's less of a risk. What's the EEOC's remedy for failure to file? Well, they can actually go to court and ask for an order to force you to file. But frankly, that's highly unlikely. There are going to be a lot of folks out there who are going to have trouble with this. And, you know, the EEOC, in theory, might make an example out of 1 or 2, but are they likely to tee up thousands of employers? Unlikely, especially given the current administration. Of course, what's the con of that? Well, you know, internally and externally, you're not compliant. And to the extent that people are asking, you would have to truthfully say that you did not file. To the extent you have to certify compliance with respect to internal contracts or outside agencies or other groups, you would not be able to certify that you did this filing. And the other risk, obviously, is that the portal will eventually close, and you won't be able to file at some point, whether you want to or not. And frankly, you know, that approach is fairly risky the more public-facing you are, to the extent that you're a publicly traded company, to the extent that you're a retail organization who answer to customers, frankly, and shareholders more than you do some entities. Not filing has a higher level of risk. Option number 3 is to wait and see what happens. Wait just a little bit. Not long, but wait a little bit after the deadline. See if the EEOC goes back to the original district court and asks for some other special relief. See if anything interesting happens on the appeal. See if some additional time is going to be granted such that the appeal may play out to the benefit in favor of employers. It's unlikely for the reasons I mentioned. I am very concerned about the fact that, frankly, you know, this appeal is going to be largely moot once everybody files away. But one strategic option is to wait and see. The big pro of that, obviously, is it holds back filing bad data that will be public record till the, you know, nth moment when you have to do it. The hard part for employers, I think, will be making a judgment call as to when that timing is. So those are your strategic options. But for the most part, I think most employers who are under this obligation are trying to move forward with option 1. We do have some clients who are strongly thinking about option 3. Frankly, we also have some clients who are thinking hard about option number 2. But that depends on you, and that depends certainly on your individual risk profile. So that brings us to other things that were the big topic at the National Industry Liaison Group Conference. And the number one issue, separate apart from EEO1 reporting, is the OFCCP's ongoing emphasis on focused reviews. And for those who aren't familiar with what a focused review is, it's different than the typical OFCCP audit that covers a variety of different topics with respect to race and gender, diversity and applicant tracking, and disability and vets and other sort of compliance issues. There are a myriad of things that go into a standard OFCCP affirmative action plan audit. For focus reviews, the idea is that the agency would focus on one of those topics, for example, on disability alone or on veterans alone. And they would ask a lot of questions about that, some of which would normally be covered in a regular review, but the scope of the, quote, focus review would be limited to the topic du jour. In theory, this is a great practice. OFCCP has always had this authority, but they've used it in a more limited manner. This was a topic that came up last year at ILG and was proposed by the new director, Craig Lean, at that time. And his viewpoint on this is that, quote, we can use focus reviews to draw attention to populations that have been underrepresented in the past and, frankly, under-enforced. And he's probably right about that. It is a great tool for that. It's a personal focus of him, no pun intended, in part because he has a daughter himself with a disability. He talks openly about that. He's very interested in this topic. And he's very interested in trying to move the ball forward for all individuals and not just individuals focused on gender, race, which is the core bread and butter what OFCCP does. As part of that, and under the last CSALs that came out, the corporate scheduling announcement list letters, there were about 500 Section 503 and disability sort of focus reviews that came out as part of that batch. Those CSAL audits have been moving along, but they indicated at ILG, which I thought was interesting, that there are no on-sites that will be scheduled before September 2019, in part because the agency is still conducting training for their personnel on how to do these focus reviews. And so on-sites are coming, but they're not here yet. Director Lean also noted that even though the first batch of CSALs that came out for focus reviews had the specific focus and intent to cover Section 503, up on slate for the fall of 2019 are vet CSALs, and then the agency will be moving forward after that. We see CSALs and focus reviews focused on promotions and then terminations. That's the theory. What's the practice? Well, the practice is you need to pay attention to this. I think a lot of people thought, well, focus review, that's not bad. It's a lot better than getting a full-scale review. We can slide through this. That may be true, but you shouldn't think of it as audit light. These are, full-blown audits in many ways. They were just extremely focused on the topic at issue. These focus reviews are typically conducted at the headquarters facility, which has its own inherent risks. They also noted at the ILG, which I thought was interesting, that all of the focus reviews will have on-sites, no matter what the data shows. And this is a terrifying thought, that all the on-sites will typically be, quote, at least a week. I'm not a big fan of the at least part, but that sounds like not audit light. Common 503 requests that we're seeing so far, well, a lot of questions about, as you can imagine, outreach and recruitment, the application process and applicants' accessibility to that process, requests relating to policies and training and procedures for reasonable accommodation requests and how employees learn about those procedures. They're also starting to ask for individual level applicant and comp data for disabled individuals, which we'll talk about. And certainly they also want to know a good bit about your accommodation practice, which includes typically a request for a list of all individuals who have requested an accommodation in the past 1 to 2 year period, the date of those requests, the outcome of that request, and the reason for any denials. I would say, as a practical matter, that's very problematic, that last one in particular, in part because most employers, for good reason, don't keep a database of all of their accommodations. I think most people are taught, like we teach clients, you're better off not knowing an individual's disability in many respects. And to the extent you do know it, you need to try and keep that information shielded in some ways from other individuals within the organization for all sorts of different reasons. Besides the ADA confidentiality requirements, it's just not good practice. By the same token, for that same reason, clients typically don't keep a running log of accommodations, and trying to pull this information together on the back end from thousands of files and electronic records can be quite daunting. Other things that I will call out from ILG that related to focus reviews, and these are things that Director Lean himself said, and this gets to be, in my mind, a little bit more edgy. And, like anything else at a conference, I'm not sure, frankly, whether Director Lean meant what he said when he said some of these things, and because he spoke fairly openly. He was scripted somewhat, but not scripted in other ways, and he may have simply been riffing. On the other hand, if this is what he means, it could be problematic. So I'll give you one example. This is one quote in his speech. He said, "I feel like we've treated disability differently than race and gender. You can deny an accommodation to an individual even if they really need it." And that's true. There is no doubt that historically employers and the government has treated disability different than race and gender. The reason for that is it has an entirely different legal structure. Section 503 and the ADA has a totally different legal structure than the Civil Rights Act in 1964, in part because not everybody is disabled. And proving who is disabled is itself an issue. Likewise, there are limits on accommodation. He's right. You can deny an accommodation to an individual even if they really need it. There are exceptions, such as undue hardship. That's part of the legal parameter. Bottom line is you do get the sense, rightly or wrongly, that the director and the OFC may believe that accommodations, in the most part, should be granted and should be denied rarely. And to the extent they're denied, they're going to look behind that. At a minimum, that's what they mean. On the maximum, it's a little scary that they think that somehow the legal structure are the same. Another comment that the director indicated, he said, "I think VEVRA could be used to look at USERA systematically." And when he said that at the conference, I think everybody in the crowd sort of wondered, really? Yeah, I'm not quite sure how that is, in part because USERA, again, has a different legal structure than VEVRA. It has some overlap in what they cover, but in many respects, not really. And the other interesting thing is, frankly, I'm not sure OFCCP has jurisdiction on USERA. There's no doubt that the DOL does, but whether OFCCP specifically has enforcement authority, I don't know about that. I'm not sure I would rule over on a request that's USERA related. Likewise, there's a bunch of different chatter, and we heard this at several different sessions, including Director Lean's session. He said that OFCCP needs to look at disability the same way it looks at gender and race. And again, that's problematic. What you heard a lot of buzz about is whether and the extent to which OSP is going to use the statistics that's reported on on disability and on veterans in the same way that it looks at race and gender data, which is more robust, and run it through some type of disparate impact analysis. The problem with that is twofold. Number one, that wasn't the grand bargain that everybody struck when we started reporting disability and veterans data originally. The reason the disability data and the veterans data are called benchmarks and not goals, and the reason OFCCP, at least back when they adopted this, promised that they would not use that statistics against you with respect to sort of statistical enforcement authority is in part because the data itself is largely limited because individuals simply do not like to self-disclose their disability or veteran status, especially so with disability, less so with veterans. And so when you see the self-disclosure information, you automatically know that for the most part, it is not accurate, that you probably have many more veterans and many more disabled individuals in your organization applying, being hired, being regularly employed than your data would show. So when you run statistical analysis on that data, it itself is extremely, extremely problematic. So to the extent that OFCP does intend to do that, I think most employers have severe concerns about that. So, other regulatory changes on the horizon with OFCCP. Well, you may have seen that on August the 2nd, some new compliance assistance guides just came out that were very helpful. This is part of Director Lean's very positive sort of transparency initiatives. There's a new OFCCP at a glance guide, a what federal contractors can expect guide, a postings and notices guide, and a record keeping guide, all of which are very helpful. There was also a new August 9th contractor assistance portal that just opened up with OFCCP. Again, this is something that was talked about last year at National ILG, but has actually moved forward with implementation this year. That portal is now open. Two other things that were mentioned, there were coming attractions. Well, apparently there's going to be some new technical assistance guides coming out on disabilities and vets and for promotions, again with the idea of helping employers get ready for these focus reviews. That's all very positive, I think. Director Lean also mentioned that there would be new FAQs coming out with respect to, quote, equitable and sufficient parental leave. This is a hot topic in all sorts of different circles for good reason. Equitable parental leave, I understand. Sufficient parental leave, probably a little bit more controversial. I think the reason for that is that there is no requirement that federal contractors or other private employers adopt paid or other parental leave outside of the Family and Medical Leave Act and some state laws, and thus sort of second guessing whether that leave is, quote, sufficient or whether the failure to have it has some sort of adverse impact on populations, I would submit, again, is controversial, in part because to the extent the government wants employers to do paid parental leave or otherwise, or to have certain standards for it, they can simply regulate it. But to do it indirectly through adverse impact analysis, which is somewhat questionable, I think is fairly controversial. So we'll see what they mean about, quote, the sufficient part, but just keep in mind we'll probably see some FAQs on this in the coming months. Other hot topics at ILG, well, OFCCP and compensation continues to be a big issue. One hot topic of discussion was whether there are going to be new revisions to the, quote, new 2018 directive on compensation that came out in light of the analogic decision, for example. There's a good question about whether or not the OFCCP should be allowed to do regression variables regarding pay practices that are basically, quote, generic or irrelevant to an actual employer's on-the-ground pay practices. The analogic decision would indicate no. The directives are a little unclear on that issue. Whether OFCCP revises those directives in light of analogic, there was some buzz about that. That may be in the works. There may be also some discussion about whether or not the OFCCP needs to soften some of the guidelines that were in that directive. For example, the OFCCP's Rule of 5 that requires each regression variable to relate to at least 5 individuals. That's a fairly controversial standard, and whether the OFCCP pulls back on that in some form of new directive or re-guidance of some type in 2019 or 20, we'll have to see. One thing that was definitely on the topic, though, at ILG was there was a lot of conversation and discussion about what I would consider to be the inappropriate merging of pay and promotion discrimination theory. And you heard this from Director Lean, but we also heard this in several other sessions from OFCCP and EEOC. Specifically, Director Lean in his session specifically said, I believe most comp issues we are finding are really promotion issues in disguise. And that, I can see partially what he means by that, and but in many respects, I don't. Promotion issues, aside from comp, are much more complex. And comp itself has all sorts of different variables that could impact it. But simply doing some form of simple hierarchical analysis or pay distribution analysis in order to sort of look at and question promotion sort of ignores key drivers for things like tenure and experience and performance, and people who self-select in and out of the workforce and in and out of the promotion pool at a given time. They're simply different things. They have different tests. There are different theories behind that. And to the extent that OFCCP is going to start merging those theories to sort of use comp data to sort of pivot to sort of a promotion case, I think that could be highly problematic. Other things we heard at ILG, well, there was a good bit of discussion about functional AAPs or FAAPs. There was a funny session that someone did, which I really liked the title. It was FAAPs are for SAPs. It's debatable whether they are or not. OFCCP certainly doesn't think they're for SAPs. There's a new August 21 directive that came out, frankly, trying to encourage more employers to do functional AAPs. For those who aren't as familiar with that, a functional AAP is when you're doing an affirmative action plan that's not by location, but by an operational sort of component, so that you can actually have an AAP that sort of follows your operational lines among different locations. Of course, that requires advanced OFCCP approval, as it always have for the regs. But the new directive indicated that they're loosening up on that standard a little bit, that they're no longer considering compliance history when reviewing a request. That the OFCCP is also promising to be quick about getting to it and making a determination about whether to approve it or not within 60 days. Some of the advantages, they say, to doing functional AAPs, to the extent you get an agreement with OFCCP about it, the term has been increased from 5 years to 3, up from 3 years to 5. Also, to the extent that you are unfortunate enough to get selected for an audit as part of a FAAP, to the extent you pass through it with colors, you would be off the audit list for a minimum of 36 months, where right now for non-FAAPs that's 24 months. So that's a positive. They also removed the requirement in the new directive that FAAP contractors undergo at least one audit during the FAAP agreement term. So again, that's positive. This is a big issue with director lien and the OFCCP in general. They currently have 60 to 70 FAAPs. They indicated they were hoping to get that number up to 1,000 by the next fiscal year. The question you have to ask yourself as an employer is it worth the expanded audit scope risk? That's a fair question. The positive of the FAAP is it may better align to your reporting. It may better align to the realities of your organization, especially for comp. The downside is you're picking up a lot more facilities. There's just no doubt about it. And typically FAAPs are broader, they contain more data, and more data points typically don't benefit the employer. So, speaking of things that may or may not benefit the employer, the other big topic at ILG was OFCCP's continued push for corporate-wide early resolution process conciliation outcomes. There was, as you may recall, a directive that came out in November of 2018 about this. This was a little bit of a push last year, but a much bigger push at ILG coming into this year, inspired in part by the JBS Swift consent decree resolution that came out months ago. But just keep in mind, they were pretty clear at ILG about this, that you should not think that IRPs are some sort of get-out-of-jail-free card. They will require back pay in order to enter into some sort of corporate-wide resolution, and that they will also require semi-annual reporting during the 5-year period in return for a 5-year moratorium for your corporate-wide organization. 5-year audit moratorium sounds great, especially for organizations that have a lot of audit activity. Having said that, keep in mind you're going to have required semi-annual reporting back to the OFCCP for that 5-year period. The scope of that reporting, in many respects, remains unclear, and I think is going to be individually tailored in these CAs. Likewise, how OFCCP responds to disparities to the extent they arise in that reporting, and whether it's just simply going to put you into some sort of perpetual audit stance is unclear. And that's probably the biggest downside to these corporate-wide ERPs. But again, this is something that OFCCP is very excited about, given the scope of them and the data that comes with it. I can see why. Whether that's good for you, That's a larger strategic discussion. So, other enforcement priorities and buzz of note here before we close. Well, for EEOC, there's no doubt EEO1 Component 2 is at the top of their list for things they're focusing on, in part because they have no choice. They've got a court-ordered gun to their head, and they are moving forward, whether they want to or not. And so how they deal with that data, how they then sort of go through and use it, to the extent they use it at all going forward, will be a big part of their discussion going forward for fiscal year 2020 and 21. The other focus of the EEOC, and Commissioner Lipnick was very clear about this, is going to be age discrimination. And that's probably thoughtful and appropriate. Commissioner Lipnick noted, I thought this was catchy, she said it's the, quote, second open secret in most of our workplaces across the United States after harassment. The agency spent a good bit of time focusing on harassment with the Special Commission over the last several years. And you can definitely see where the Commission thinks that age discrimination, especially with the aging population, more folks who remain in the workforce, et cetera, that are above 40 and well into their 50s and 60s now and 70s, it's a big issue. And EEOC thinks that it's going to be an enforcement priority for them for the fiscal year ahead, and I think employers should bear that in mind. Victoria Lipnick also noted, she had a funny comment. She said, yeah, she said, I take some solace in the fact that the first band of the millenniums will actually begin hitting the above 40 number in a couple of years. And I think when she said that, there was like an audible gasp in the audience about that. But she's right. That generation will be crossing into protected classification shortly, and it just emphasizes the fact that the population, at least in the workforce, is definitely aging. The EEOC also noted, and Vicki Lipnick was big on this, that they've had, frankly, the lowest backlog that they have in years, lowest in over 14 years, she noted. And that's exceptional. What that means is, frankly, they're getting much more efficient, and charges are getting the attention they need, but likewise they're moving away from charges that, frankly, don't need that same level of attention, and they're working through that pile. So that's good. For OFCCP, like I mentioned before, focus reviews, disabilities, and vets are definitely on the tap for fiscal year 20, to be followed by promotions. Likewise, compensation is a theme that will just not go away. Two of the biggest awards that came out in the last calendar year from OFCCP were both comp-related, and they certainly have staffed up on that. They believe it's important, and those continued focus and audits will continue. So, other things of note that I thought jumped out to me at ILG, well, you know, the OFCCP indicated that they're looking at making changes to the self-identification form to make it more welcoming. That was their quote, more welcoming. And it is intimidating, frankly. It's got a lot of legalese in it. It's got a lot of information. You are required to use certain of the language in those forms, whether you like it or not. It can be very intimidating, and it drives down self-disclosures. I think they acknowledge it drives down self-disclosures. The ironic part about this, at the same time that they're indicating that they know the form is lousy and that it drives down self-disclosures, they're at the same breath proposing heightened enforcement using that same inaccurate data. So that's ironic, but you know, we might be seeing some changes to that form in the coming year or so. Likewise, I was at a session with the EEOC, and they indicated that they too were looking at potential changes to the definitions used for race, and that's probably more interesting. We'll see what comes of that. They indicated that one of the reasons they're looking at it, there continues to be a lot of confusion, and I think we've all seen this regarding Hispanic ethnicity versus other listed races and how people fill that out. And a lot of people, frankly, fill that out incorrectly, or at least have a lot of questions about that. They're taking a look at that. They also said they're taking a look at whether or not to add other races. For example, Middle Easterners have always been a hot topic because at present they're technically reported as Asians on the current form, and a lot of individuals of Middle Eastern descent would argue strongly that they don't consider themselves to be Asian and do not like filling that out on the form. And so that may be a hot topic for consideration. One thing they noted is that for the moment, there are no plans for now to add additional gender categories. That may change, again, if they took a hard look at this. But for the moment, they said that was not on the table. Other things that I will note that I heard at ILG, well, at one point, Director Lean in his speech said, we are, quote, prioritizing cases where there is anecdotal evidence of discrimination and statistical significance. And at first, that didn't sound bad, but I will tell you there was a little bit of buzz at ILG about whether that was some sort of walkback of the OFCCP's prior FAQ on the topic. Because if you look at the prior FAQ, it's a little bit more definitive. It says the OFCCP will be less likely to pursue a matter where the statistical data are not corroborated by non-statistical evidence of discrimination unless the statistical evidence is exceptionally strong. And, you know, this has been, frankly, a talking point of industry for a long time, that the government just uses these raw statistical data points to make cases of discrimination. They'll come and audit you for a week. On site, they'll go through a desk audit review period of months and months and months, collecting reams of data. They'll come back with no evidence of analytical discrimination, and yet they'll come back to you and say, but the statistical evidence indicates X, and for this reason alone, we're moving forward. Basically naked statistics. And there are reasons for that, but it drives most employers crazy. And the fact that OSP is going to be backing off on that was deemed to be sort of a positive indicator whether or not by that statement the director is actually walking back that earlier commitment. We'll have to see. The other positive thing I heard at ILG from Director Lean on the other, as a counterpart, is he indicated at his session that, you know, when there is a notice of violations, when there are issues, we will, quote, identify the policies or practice that are causing the discrimination so you can fix it. And again, this has been a big issue with employers, in part because individuals like myself and others have argued that OFCCP, frankly, just doesn't follow the law, that there is a prima facie elements that have to be proven by the Commission before moving forward with the notice of violation, and simply pointing to statistics and saying that, oh, by the way, we think this is, quote, an indicator of discrimination. And you say, well, great, so what do you think the practice is? What are we doing wrong? Is it a particular question we're asking on the interviews? Is it the type of tests that we're running and giving to individuals pre-offer? Is it the screening that we're using for drug testing? Is it some other policy or practice or mechanism that we're engaging in at our organization that we need to change? What can we fix? If you think we're doing something wrong, okay, great. What do we need to do to improve if it's a neutral practice that's causing this discrimination and not high-test, straight-up, full-time discrimination? And unfortunately, a lot of times OSP will say, we don't have to tell you that, or we don't know. But we just know that you have, quote, discriminated. And so to the extent that OSP and the director is trying to sort of move the dial a little bit and actually get back to a prima facie case, that would be fantastic. And I think people would be very excited about that. Are we seeing that on the ground in actual audits so far? Not really. There definitely is a point where OSP is trying to be more transparent about their theories of recovery, about what they're seeing in the data, but as to whether or not they really are pointing to the policies or practices, so far we're not seeing that. A lot of times all you see is OFCCP pointing to a step analysis to say, oh, we think that you have an indicator with respect to screening, or you have an indicator with respect to the interview stage. But as to whether particular individuals are discriminating, i.e. high-test discrimination, they're not saying, or as to whether particular interview questions or practices are problematic, they aren't saying. And so merely pointing to something like an interview as problematic is not helpful, because employers certainly aren't going to get rid of interviewing employees for hire anytime soon. So the fix is really sort of just not practical. So we'll see. It's positive if it actually moves in the direction as noted, but whether that really is what we're going to see, we'll all just have to wait and see for the fiscal year to come. So with that, I know we're about out of time. I am going to see if there are a couple of questions that we can answer, and then we'll wrap up. Certainly, if we don't get to your questions, I will email you separately and reach out about the individual question that you raised, and we'll try and get an answer for you. So here's question number one. He said the EEO1 pay data makes no sense given the manner in which we are pulling it. Can I annualize the data for submission so it's in a better form? The short answer to that is that would be great, I suppose, but the answer is no. Per the EEOC's instruction manual, employers are required to use the W-2 Box 1 data for better or for worse, and the instruction guides are clear that that is without annualizing the data for partial year employees. That's also, frankly, without adjusting the data for full-time equivalents with respect to part-time personnel. And so when you look at the data, it is going to be apples and oranges data. You're going to be looking at exempt and non-exempt individuals. You're going to be including part-time and non-part-time individuals. You're going to be including full-year employees and partial year employees, all of which makes the data very wonky. So the answer to that is, unfortunately, no, you're stuck. Other question, and last question probably before we run out of time. Given the increased effort behind focus reviews, do you have any suggestions for employers going into the fall? Sure. I think there's no doubt, especially with respect to disability and veteran status, the data is underreported. And your own internal data is underreported. But OSB is going to be paying more attention to that benchmark and other data. And so, most employers would do well, I think, to think hard and long about how they survey their employees for that information. You're already required to sort of resurvey employees every 5 years per the OSB regulations. And that time period is coming up on us. And so if you're getting ready to resurvey your employees, I would simply suggest you give it a hard push, a top-level push from your E-suite or otherwise to sort of emphasize to individuals that we really want to know this information, that it will be kept confidential, it will be only used for governmental reporting, but it's important that we try and get a full assessment of individuals, and we would encourage you to raise your hand. Now, separate from that, do you want to supplement the data in some other way? We do have clients who are going back through their FMLA data, their STD data, their accommodation information to the extent they keep that, to try to identify individuals who are disabled within the meaning of Section 503 who have not otherwise self-disclosed, so that they can then supplement the form with information of which they are aware. That's more tricky for a variety of different reasons. It's also more time-consuming, but we do have some people who are doing that. So that's the answer to that question. I'm sorry we're out of time for everything else. I know you may have other questions and thoughts that have come to mind. The conference this year was very positive, I thought. I think there's definitely a better tone coming out of OFCCP and EEOC than we've seen in the past. I think they are trying to be more helpful. They're definitely trying to be more transparent. They're trying to have a dialogue. I thought it was very positive at ILG that, frankly, the director was there and most of the regional directors were there for the entire conference. They were not just there, but they were engaged and active and talkative and approachable, and that's certainly positive. The same goes with the EEOC and their representatives. I think they're trying hard to show a different face of the government and to try and be more open about their processes and what they think are important. By the same token, whether that's really changing what happens on the ground with respect to enforcement activity, that's a different issue. But overall, positive is positive, better is better, and we're happy for that. Speaking of better is better, if you have questions about any of this, if you need help with any issues that you're confronting, or if we could be of any assistance in any way, certainly let me know, let others on our labor and employment and affirmative action team know, and we'll be more than happy to help you. That's it. Thank you for joining. We hope this has been useful, and we hope that you'll have a great rest of the afternoon. Take care.